litigation privilege, in my view, and the way that I sort of understand it, is just like a sort of subcategory of solicitor client, right? It's your lawyer doing stuff in anticipation of the case for you to win your case or to deal with your case. It doesn't even have to be to win, right? So let's say you're in a motor vehicle accident and the lawyer says, okay, we got to go get an expert opinion about the car or about your injuries or about if you were driving drunk or whatever it is. If you're not planning to use that expert opinion in your trial, then it could be litigation privilege. Let's say you just want to do the research about, you're the lawyer, you want to do research about car case law, car injury law, or whatever, right? And you make a PowerPoint presentation in anticipation of this litigation, privileged. It's part of what your lawyer's doing for you, right?
Question. Okay, so there's a lot of self-reps out there who are also watching this channel. Now, does that mean that if you don't have a lawyer, you cannot claim litigation privilege?
Okay, so again, I want you to double check this because I don't know. That's actually a hard question. My gut feeling says if you're working in furtherance of your case and you're creating work, right, that you do not plan to use, then it could be privileged, right? I don't see why it wouldn't be. But
I think it is, because I looked this up. And
okay, so I should be asking you then, Heather.
I just thought that you would know. I thought that you have more insight, but
I mean it's a question for a specific case that I haven't been involved in. But if you know and it makes sense to me, right? That's what I guessed, and you're confirming because it serves that same purposive approach, right?
Yeah.
We're trying to let people, navigate the legal system as best they can and not interfere with that. But and one thing that's important, you can't then use that later in your case, right? You can't say, well, I got this expert involved. It's privileged until I decide it's not privileged anymore, right? It would be, that would be sort of using the rule not for what it's intended.
Kind of abusing it, right?
Exactly.
That would be abusing it.
Okay, and then the last one, and this is the one that gives the most confusion of all.
Oh no.
As far as I'm concerned, at least, is settlement privilege. So here we go. We're going to look at it again through the eyes of, we want to further something. We have an issue. We want to keep the importance of that issue against getting to the bottom of like your actual resolution, right? So in this case, it is negotiations and settling matters. We don't want to interfere with litigants trying to settle their problems, right? Rather settle than have a court do it. So if you are a litigant and you send an offer to settle that says, it's very clearly an offer to settle, like I'll pay you $1 million in exchange for this case going away, or whatever it is, some sort of settlement discussion, you can't bring that into court until after the court decision has been made, right? The judge can't use that in deciding the case. Not disclosable. You've privileged information. A lot of people will say, if you're sending an email saying, I'm going to I'll settle this case if you'll take $1 million, they'll put on the top of that email, they'll say without prejudice, right? They sort of copy and paste that in. And that's nice to show that you think that this is a settlement offer, right? It doesn't really mean much in real life. Like either you're settling or you're not, right? Some people write without prejudice and then talk about stuff that's not settlement, and it's not privilege, right? And then one of the cases I read to prepare myself for this, someone said without prejudice, I admit that this and this happened, but I'll settle the case for this and the other thing. And the other side said, well, if they're admitting it, I want to put that in. I want to put that into in front of the judge. They had a fight. Is that privileged or not? And the judge said, it's not privileged. Admitting something isn't a settlement, right? It's admitting something. And in this case, you're admitting you're actually, I mean, remember, they're all going to be factually different. So in this case, the judge found that that admission in that email was contrary to stuff that they'd written in an affidavit. So they were admitting they lied, which the judge said that's not something we were trying to protect.
Oh, that's interesting. Okay.
So the stuff about how much they'll settle for, privileged. They blacklined that out.
I see.
But the part that said, I admit, I think it was a discovery issue. I found out about the claim on some date, which changed the limitation period. They said, actually, maybe I did find out about on the date. They said, that's not privileged. Oh, so that's the three, right? So the solicitor client, that's between you and your lawyer, right? It's very important that, you know, we keep conversations between litigants and their lawyers private for many different reasons. The other is litigation, which is work that your lawyer does, sometimes called, there's another work product or something. Work
product privilege,
same thing. We want to make sure that you're able to explore different avenues of your case without it being put out in front of the judge and to the other side. And then the third is settlement privilege, which is negotiations. Now, it's important to know that that privilege only maintains until the case is over. Once the judge says, I find this guy liable for $1 million, the judge will usually say, if you have cost submissions, give them to me within 20 days. All that, the negotiations can go into the cost submission.
Oh my goodness, I see. Okay.
Yeah, and I think the reason behind that is, well, the reason behind that is you know, per the rules of civil procedure and per the costs. The judge wants to know who was being and who wasn't, right?
Right.
Did some party waste the court's time by having to litigate, have a whole trial when there was an offer better than that they should have taken, all that stuff. But I think when you get down into like the real nitty gritty, settlement privilege is gone once there's no settlement, right? There's a case has been decided by a judge. What settlement is there privilege, right? So it's not privilege anymore. And the judge can look at those offers and decide, you know, on costs and things like that.